School of Management Studies IGNOU presents an audiobook on the course MMPC-013 Business Law for MBA program. Block 2 Business Forms and Legislations. Unit 4 The Companies Act 2013 Part 2.
Principal documents of a company. There are three fundamental documents of a company. They are: Number 1. Memorandum of Association. It is the charter of a company which lays down the objects of the company and all the specific functions, operations and limitations. Number 2. Articles of Association. It is the document that constitutes all the rules and regulations for the conduct of the internal management of the company. And number 3. Prospectus. It is a formal and legal document issued by a body corporate describing a company's financial background and the securities that have been put on sale. Memorandum of Association or MOA. Memorandum means the memorandum of association of a company as originally framed or as altered from time to time in pursuance of any previous company law or of this Act as per Section 2, Clause 56. It is the document that regulates the company's external affairs and complements the Articles of Association. It is the most important document and commonly referred as the Constitution or the Charter of the company. It is the very foundation on which the whole edifice of the company is built. It defines the constitution and the scope of the powers of the company with which it has been established under the Act. A company has to stick to the provisions laid in the memorandum, no matter how crucial may be the necessity for the departure. It cannot enter into a contract or engage in any trade or business which is beyond the power conferred on it by the memorandum. If it does so, it would be ultra vires the company and void. The memorandum of a company shall be in respective forms specified in tables A, B, C, D and E in Schedule 1 as per Section 4. Table A is for company limited by shares. Table B is for a company limited by guarantee and not having a share capital. Table C is for a company limited by guarantee and having a share capital. Table D is for association of an unlimited company. And Table E is for an unlimited company and having share capital. The memorandum and articles of a company must be as closed to model forms as possible depending upon the circumstances. Contents of Memorandum. The memorandum of a company shall state: Number 1. Name clause. Name clause consists the name of the company with the last word limited in the case of a public limited company and private limited in the case of a private limited company. This clause is not applicable on the companies formed under Section 8 of the Act. As per MCA notification dated 5th of June 2015, a government company's name must end with the word limited. In the case of one-person company, the words one-person company should be included below its name. If a company changes its activities which are not reflected in its name, it shall change its name in line with its activities within 6 months from the change of activities after complying with all the provisions as applicable to change of name. Number 2. Domicile or registered office clause. This refers to name of the state in which the registered office of the company is to be situated. A company shall, on and from the 15th day of its incorporation and at all times thereafter, have a registered office capable of receiving and acknowledging all communications and notices as may be addressed to it. Number 3. Object clause. It states, the main objects which the company wishes to pursue at the time of incorporation, and objects incidental to the attainment of the main object and other objects as well. Number 4. Liability clause. This refers to the liability of members of the company, whether limited or unlimited, and also state, in case of a company limited by shares, that the liability of its members is limited to the amount unpaid, if any, on the shares held by them, and in the case of a company limited by guarantee, the amount up to which each member undertakes to contribute. That is, contributes to the assets of the company in the event of its being wound up while he is a member, or within 1 year after he ceases to be a member, for payment of the debts and liabilities of the company, or of such debts and liabilities as may have been contracted before he ceases to be a member, as the case may be, and to the cost, charges and expenses of winding up and for adjustment of the rights of the contributories among themselves. Number 5. Capital clause. In case of company, the amount of the share capital with which the company is to be registered, that is authorized capital, the number and face value of shares into which the capital of the company is divided, and the number of shares the subscribers to the memorandum have agreed to take, indicated opposite their names, which shall not be less than 1 share. A company not having share capital need not have this clause. And number 6, association clause. The memorandum concludes with the association clause. It contains declaration from several persons whose names are subscribed are desirous of forming a company and agree to take shares mentioned against the name of each person. Every subscriber to the memorandum shall take at least 1 share and shall write against his name the number of shares taken by him. All these clauses are called compulsory clauses or conditions. In addition to these, a memorandum may contain other provisions, for example, rights attached to various classes of shares. In the case of OPC, the name of the person who, in the event of death of the subscriber, shall become the member of the company should be there. The memorandum must be printed, divided into paragraphs, numbered consecutively, and signed by at least 7 persons, 2 in the case of a private company and 1 in the case of one-person company, in the presence of at least 1 witness who will attest the signatures. The particulars about the signatories to the memorandum, as well as the witness as to their address, description, occupation, etc., must also be entered. The memorandum of association of a company cannot contain anything contrary to the provisions of the Companies Act. If it does, the same shall be devoid of any legal effect. Similarly, all other documents of the company must comply with the provisions of the memorandum. The Memorandum of Association or MOA can be altered any time, but there are certain conditions which have to be complied before alteration as per Section 13. Articles of Association or AOA. Articles means the articles of association of a company as originally framed or as altered from time to time or applied in pursuance of any previous company law or of this Act as per Section 2, Clause 5. It is a document supplementary to the Memorandum of Association which deals exclusively with the rules and regulations of the internal management of the company. These articles or rules are commonly known as the bylaws of the company. These express a contract between the company and its members and among the members themselves. These are subordinate to the memorandum and hence not in any way contradict it. Schedule 1 of the Act gives 4 formats in Table F, G, H, I and J which may be used to frame the articles of association. A company may adopt all or any of the regulations contained in the model articles applicable to such company. Contents. Section 5 of the Companies Act 2013 seeks to provide the contents and model of articles of association. The section lays certain laws which are: Number 1. The regulations for management of the company. Number 2. Such matters as are prescribed under the rules. However, a company may also include such additional matters as may be considered necessary for its management. And number 3. Provisions for entrenchment. Usually, an article of association may be altered by passing special resolution, but entrenchment makes it more difficult to change it. Entrenchment means making something more protective. The articles may contain provisions for entrenchment to the effect that specified provisions of the articles may be altered only if conditions or procedures as that are more restrictive than those applicable in the case of a special resolution are met or complied with. The provisions for entrenchment shall only be made either on formation of a company or by an amendment in the articles agreed to by all the members of the company in case of a private company, and by a special resolution in the case of a public company. The company shall give notice to the registrar of such provisions in such form and manner as may be prescribed. Section 14 of the Companies Act 2013 vests companies with the power to alter or add to its articles. A company cannot divest itself of these powers. Matters as to which the memorandum is silent can be dealt with by the alteration of article. Prospectus. Companies raise their enormous capital needs from banks, international financial institutions, defined group or inner circle called private placement of securities, as well as from the general public called public offer. These creditors lend only if the company is creditworthy. In order to assure its creditors that it is creditworthy and has business acumen to develop, manage, and earn profits for its shareholders, it offers the details of its competence in a document called prospectus. It is after studying this document the creditor makes his decision to accept it. Thus, a contract between a public company and its creditors comes into existence. According to the definition under Section 2, Clause 70, prospectus means any document described or issued as a prospectus and includes a red herring prospectus referred to in Section 32 or shelf prospectus referred to in Section 31 or any notice, circular, advertisement or other document inviting offers from the public for the subscription or purchase of any securities of a body corporate. The definition includes any notice, circular, advertisement or any other document inviting offers from public for the subscription or purchase of securities. Legal requirements. Prospectus to be dated and signed and to state information, set out such reports on financial information as may be specified by the Securities and Exchange Board of India in consultation with the central government. Prospectus can be issued only after delivery to registrar for filing. Prospectus shall not be valid if it is issued after days from the date on which a copy thereof is delivered to the Registrar of Companies or ROC. Types of prospectus. Number 1. Red herring prospectus. Red herring prospectus means a prospectus which does not include complete particulars of the quantum or price of the securities included therein. In simple terms, a red herring prospectus contains most of the information pertaining to the company's operations and prospects, but does not include key details of the issue such as its price and the number of shares offered. According to Section 32, a company proposing to make an offer of securities may issue a red herring prospectus prior to the issue of a prospectus. It should be filed with the registrar at least 3 days prior to the opening of the subscription list and the offer. A red herring prospectus has the same obligations as the prospectus, and any variation between the two shall be highlighted as variations in the prospectus. Upon the closing of the offer of securities under this section, the prospectus stating the total capital raised, the closing price of the securities, and any other details not included in the red herring prospectus shall be filed with the registrar and the Securities and Exchange Board of India, that is SEBI. Number 2. Shelf prospectus and information memorandum. Shelf prospectus is a prospectus in respect of which the securities or class of securities included therein are issued for subscription in one or more issues over a certain period without the issue of a further prospectus. In other words, a shelf prospectus is a single prospectus for multiple public issues. Issuer is permitted to offer and sell securities to the public without a separate prospectus for each act of offering for a certain period. It is a prospectus issued by financial institution or banks. As already discussed, it is mandatory for public company which issues securities to public to issue prospectus. This is a cumbersome process. In order to save time and simplify the process, a leeway is given under law in the form of shelf prospectus. Such companies can issue one-time prospectus which will be valid for maximum 1 year. During this duration, whenever the company thinks of issuing securities as per that prospectus, it doesn't have to go through the whole process of issue of fresh prospectus. Under the Act, SEBI may provide by regulations in this behalf any class or classes of companies to file a shelf prospectus with ROC. Such prospectus is to be submitted at the stage of the first offer of securities, indicating a period not exceeding 1 year as the period of validity of such prospectus. The validity period shall commence from the date of opening of the first offer of securities under that prospectus and in respect of a second or subsequent offer of such securities issued during the period of validity of that prospectus. No further prospectus is required. An information memorandum is required to be filed by a company filing a shelf prospectus which shall contain all material facts relating to number 1. New charges created. Number 2. Changes in the financial position of the company as have occurred between the first offer of securities or the previous offer of securities and the succeeding offer of securities. And number 3. Such other changes as may be prescribed with the registrar within the prescribed time prior to the issue of a second or subsequent offer of securities under the shelf prospectus. The information memorandum shall be prepared in form PAS2 and filed with the registrar along with the prescribed fee within 1 month prior to the issue of a second or subsequent offer of securities under the shelf prospectus. Number 3. A bridge prospectus. A prospectus is a very voluminous document and one cannot be expected to read it completely. An abridged prospectus is a summary of the prospectus containing such details as prescribed by the SEBI. According to Section 2, Clause 1 of the Act, a abridged prospectus means a memorandum containing such salient features of a prospectus as may be specified by the SEBI by making regulations in this behalf. Section 33 makes it compulsory that every application form for the purchase of any of the securities shall be accompanied by an abridged prospectus, and a copy of the prospectus shall, on a request being made by any person before the closing of the subscription list and the offer, be furnished to him. Number 4. Deemed prospectus or offer for sale. The document offer for sale is an invitation to the general public to purchase the shares of a company through an intermediary such as an issuing house or a merchant bank. A company may allot or agree to allot any shares or debentures to an issue house without there being any intention on the part of the company to make shares or debentures available directly to the public through issue of prospectus. The issue house in turn makes an offer for sale to the public. Any document by which the offer for sale to the public is made shall for all purposes be deemed to be a prospectus issued by the company. Securities will be considered to be offered for sale to the public if it is shown, number 1, that an offer of the securities or any of them for sale to the public was made within 6 months after the allotment or agreement to allot, or number 2, that at the date when the offer was made, the whole consideration to be received by the company in respect of the securities had not been received by it. Information memorandum together with the shell prospectus is deemed prospectus. Matters to be stated in the prospectus. A prospectus is any document through which a company communicates and invites the public to invest into it and subscribe or purchase its securities. A prospectus contains information about the financial position of the company, its directors, signatories to the memorandum, the objects of public offer, additional charges created, changes in the finance, etc. It is mandatory for a company to provide correct information in the prospectus, or it would be liable for misrepresentation and fraud. Section 26, Clause 1 lays down the matters required to be disclosed and included in a prospectus and requires the filing of the prospectus with the registrar before it is issued. The matters which are to be stated in a prospectus are: number 1. Names and addresses of the registered office of the company, company secretary, chief financial officer, auditors, legal advisors, bankers, trustees if any, underwriters, and such other persons as may be prescribed. Number 2. Dates of the opening and closing of the issue and declaration about the issue of allotment letters and refunds within the prescribed time. Number 3. A statement by the board of directors about the separate bank account where all monies received out of the issue are to be transferred, and disclosure of details of all monies including utilized and unutilized monies out of the previous issue in the prescribed manner. Number 4. Details about underwriting of the issue. Number 5. Consent of the directors, auditors, bankers to the issue, experts' opinion if any, and of such other persons as may be prescribed. Number 6. The authority for the issue and the details of the resolution passed therefore. Number 7. Procedure and time schedule for allotment and issue of securities. Number 8. Capital structure of the company in the prescribed manner. Number 9. Main objects of public offer, terms of the present issue and such other particulars as may be prescribed. Number 10. Main objects and present business of the company and its location, schedule of implementation of the project. Number 11. Particulars relating to management perception of risk factors specific to the project, gestation period for the project, extent of progress made in the project, deadlines for completion of the project, and any litigation or legal action pending or taken by a government department or a statutory body during the last 5 years immediately preceding the year of the issue of prospectus against the promoter of the company. Number 12. Minimum subscription, amount payable by way of premium, issue of shares otherwise than on cash, etc. Number 13. Details of directors, including their appointments and remuneration, and such particulars of the nature and extent of their interest in the company as may be prescribed. And number 14, disclosures in such manner as may be prescribed about sources of promoters' contribution. If a prospectus is issued in contravention of the provisions of Section 26, the company shall be punishable with fine which shall not be less than 50,000 rupees but which may extend to 3 lakh rupees, and every person who is knowingly a party to the issue of such prospectus shall be punishable with imprisonment for a term which may extend to 3 years, or with fine which shall not be less than 50,000 rupees but which may extend to 3 lakh rupees, or with both. The company has to use the funds strictly in accordance with the prospectus. Any deviations require pre-approval of the investors, and recall option needs to be given to the dissenting investors. Deviation regarding use of proceeds of issue for buying, trading, or otherwise dealing in equity shares of any other listed company is not permitted as per Section 27. Misstatement in prospectus and consequences. Misstatement means stating something that is false or inaccurate. It can either be due to commission or omission, or both. Anything in the prospectus that deceives and misleads an investor and induces him to buy shares or debentures calls for remedies both against the company and its promoters, also directors and every other person involved. Misstatement in prospectus is a serious offense and attracts civil liability against company and criminal liability or civil liability, or both, on every person who authorizes the issue of such prospectus.
We were listening to the audiobook by the School of Management Studies IGNOU for MBA program. Course code MMPC-013 Business Law. Course Coordinator Professor K. Ravi Shankar. Voiceover by Harpreet Kaur. Edited by Savita Rana. Program assisted by Tarannum Jahan and Jagbandhu Jana. Program produced by Dr. Manoj Kumar Singh. This program was brought to you by Electronic Media Production Center of Indira Gandhi National Open University.